At defendant Joseph's direction, the clerk instructed the ICE officer to leave the courtroom and wait outside the courtroom, contrary to the DHS policy. Wait a second, says the judge. There was a representative from ICE here in the court to visit the lockup. I'm not going to allow them to come in here. He's been released on this. Immediately following the proceeding, McGregor escorted AS from the courtroom downstairs to the lockup, accompanied by the defense attorney and an interpreter. Once inside the lockup, defendant McGregor used his security access card to open the rear sally port exit and released AS out the back door. The ICE officer, who had been instructed by the clerk to wait for AS in the lobby directly outside the courtroom, was unaware of AS's release out the rear sally port exit and was unable to take custody of AS pursuant to the warrant. And the question here, I think, is did the judge take active enough steps, overt enough steps, that crosses the line into obstruction of justice? This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This is United States of America versus Shelley Joseph and Wesley McGregor. Shelley Joseph is a judge in Massachusetts, and this is in the District of Massachusetts, and the violations are conspiracy to obstruct justice, obstruction of justice, aiding and abetting, and obstruction of federal proceeding, aiding and abetting. That's something that Bender from Futurama does. Let's go through the introduction and see if we can get to some meat and potatoes here. The Department of Homeland Security, Immigration Customs Enforcement is the federal agency charged with enforcing immigration law in the U.S. ICE's duties include conducting federal removal proceedings, which encompass, among other things, identifying, apprehending, and initiating the removal process of aliens in the United States who are subject to immigration court or other administratively issued final orders of removal. The Newton District Court, NDC, or courthouse, was a district court within Middlesex County, Massachusetts, that had 2 courtrooms, a clerk's office, probation office, etc. NDC had 1 to 2 assigned district court judges presiding over court matters, etc. Shelley Richmond Joseph was appointed district court judge November 6, 2017, assigned to preside at various district courts in Middlesex County, including NDC. As district court judge, she has the authority, among other things, to arraign criminal defendants, set bail, etc. And the alien subject is going to be referred to as AS, was arrested by Newton police and charged under Massachusetts law with being a fugitive from justice from Pennsylvania on narcotics possession charges. The alien subject was arraigned before defendant Joseph on April 2nd. Fingerprints were taken, submitted to national law enforcement. He had been previously deported. That's important in this grand scheme of the whole separating children thing, not to bring politics into it at all, but rather this whole controversy over the separating children thing. Part of the controversy that I just keep seeing everyone miss is where the line was between when we didn't separate children and when we did. And the line was usually on that first offense, second offense thing. So during previous administrations, children were separated, and this case has nothing to do with separation of children, but here's where the line is. Was the first offense was deportation without separation, without being criminally charged, but with it being noted that this was your first offense. And second offense is where you'd get criminally charged, and if that came with the children having to be separated, so be it. So this guy's being charged with his second offense, meaning he's already once been deported. Upon his last removal, a federal immigration official had issued an order that prohibited him from entering the United States for 20 years until 2027. After learning of the arrest, ICE issued a federal immigration detainer. The detainer requested that Newton police notify ICE prior to any release, relay any detainer to any other law enforcement agency, maintain custody of AS. The warrant stated that AS was subject to removal from the United States based on a final order, etc. Let's see, the police transferred custody of him to NDC on April 2nd and forwarded the detainer and warrant to the NDC clerk's office, with copies provided to the assistant district attorney. As part of ICE removal proceedings, ICE dispatched an officer in plain clothes to execute the warrant and take custody of AS upon AS's release from the NDC. So it sounds like they knew where he was and they were getting ready to arrest him, and they were more or less asking the Newton District Court to assist by holding him. That's going to become important later. The Newton District Court maintained a regular court calendar, etc. If a defendant was to be released from custody, the normal custom and practice in NDC was for a court officer to release a defendant from the glass dock on the first floor and out into the courtroom, which had one public entry exit. On November 10th, 2017, the executive office issued guidance to all Massachusetts state judges. The DHS policy instructed in pertinent part that the trial court employees should be mindful that courthouses are public spaces that are open to all persons, and that all persons entering a courthouse should be treated with respect and dignity, including individuals subject to civil immigration detainers and DHS employees. DHS officials may enter a courthouse to perform their official duties, and pursuant to an immigration detainer or warrant, court officials shall permit the DHS officials to enter the holding cell area in order to take custody. It does say shall permit, and this is from the Massachusetts Trial Court, the executive office of the Massachusetts Trial Court. So it sounds like the state trial court executive office. If I don't know, I'm not sure what effect that has. Massachusetts rules of court provide in pertinent part that all courtroom proceedings, including criminal arraignments, shall be recorded electronically. They're saying then that on April 2nd, defendant Joseph was assigned as the district court judge at NDC, hearing and ruling on several criminal proceedings in the courtroom on that date. The proceedings were electronically recorded. 9:30 a.m., ICE officer arrives in plain clothes. The ICE officer identified himself and his purpose to various courthouse personnel. The ICE officer then remained in the public audience area of the courtroom during the morning session. Defendant Joseph assigned a court-appointed lawyer to AS, arraigned AS on the charges, but agreed to recall the case later in the day after ordering the ADA to provide more information to the court and the bar advocate as to the fugitive charge. She recalled AS's case later in the day and asked the ADA for the Commonwealth's or state's position as to bail or detention on the charges. The ADA told the judge that they would not seek to detain AS on the drug charges, but would only make a bail request on the fugitive charge. The case was then set for further call later that afternoon. Following the 1204 proceeding, associates of AS retained the defense attorney to represent AS on the charges. The defense attorney received copies of the detainer warrant. Also following the 1204 proceeding, at defendant Joseph's direction, the clerk instructed the ICE officer to leave the courtroom and wait outside the courtroom, contrary to the DHS policy, as described above. The clerk informed the ICE officer that in the event of AS's release, AS would be released out of the courtroom and into the NDC lobby. The ICE officer complied. Then, at 2:48 p.m., AS's case was recalled, and the defense attorney appeared on behalf of AS before Judge Joseph. The following proceedings were captured on the court recorder. The clerk says, "Judge, the next case will be Commonwealth versus AS. Defense attorney has filed an appearance." The judge says, "Good afternoon." Defense attorney, "Good afternoon. May we approach?" Defense attorney, "Yes, you can approach. Thank you. Do you want to wait for your client?" "No, sidebar. We're just going to go to sidebar. Something is unintelligible is dismissed. So it's my understanding that ICE is here," says the judge. "So there's this fugitive," says the defense attorney, "but there's no warrant," says Judge Joseph. Assistant District Attorney, "Yes." Defense attorney, "There isn't unintelligible that we can tie this to him." ADA, "I don't think it's him." Defendant Joseph, "Okay." Defense attorney, "But ICE is convinced that this is the guy. I went over to ICE. They said they have a biometric match. I went through and did the research. There's 13 FBI numbers connected to this social, so something's bad with the unintelligible. My client denies that it's him. ICE is going to pick him up if he walks out the front door. But I think the best thing for us to do is to clear the fugitive issue, release him on a personal, and hope he can avoid ICE. That's the best I can do. The ADA, I don't think arguing ICE is really my defense attorney, right? District attorney, my judge. The other alternative is if you need more time to figure this out, hold until tomorrow. Defense attorney, yeah, but judge. Then it's a different district attorney. There is a detainer attached to my paperwork, but I feel like that's a separate and apart from what my role is. Defense attorney, there is an ICE detainer, so if he's bailed out from Billerica when he goes back there, ICE will pick him up. Judge Joseph, ICE is going to get him. Defense attorney, yeah. Judge Joseph, what if we detain him? Defense attorney, are we on the record? Judge Joseph, clerk, can we go off the record for a moment? Clerk, what's that? Judge Joseph, are we off the record? Clerk, no, we're on the record. Defense attorney, can we go off the record for a minute? So they're claiming that that's some sort of violation of Massachusetts rules of court, that the court recorder was turned off for 52 seconds. Then at 2:51, the court recorder was turned back on. The clerk says, now we're back on the record. After some extensive research into the various FBI numbers, as well as obtaining a photo from Pennsylvania, we don't believe that this gentleman is the same gentleman as the fugitive from justice warrant. ADA, Your Honor, with the information that I have, I don't think there is enough tying him to the Pennsylvania warrant. The great deal of other out-of-state court records, I do believe that some of them belong to this individual, but that's not what's at issue here. The judge says, okay. So at this point, I would dismiss the fugitive, count 1, okay. And there's not a bail request on counts 2 or 3. Okay, absolutely, that's fine. I would ask that I believe he has some property downstairs. I'd like to speak with him downstairs with the interpreter, if I may, says the defense attorney. That's fine, says the judge. Wait a second, says the judge. There was a representative from ICE here in the court to visit the lockup. Judge says that's fine. I'm not going to allow them to come in here. He's been released on this. Defendant, he's released, Mr. Clerk. Defendant Joseph, he is. Defense attorney asked if the interpreter can accompany him downstairs to further interview him, and I've allowed that to happen. So immediately following the proceeding, McGregor escorted AS from the courtroom downstairs to the lockup, accompanied by the defense attorney and an interpreter. Once inside the lockup, defendant McGregor used his security access card to open the rear Sally Port exit and released AS out the back door, approximately 3:01 p.m. The ICE officer, who had been instructed by the clerk to wait for AS in the lobby directly outside the courtroom, as that was where AS would be released in accordance with customary practice, was unaware of AS's release out the rear Sally Port exit and was unable to take custody of AS pursuant to the warrant. So, that was long and complicated, but do you see what's going on here? Now, there's a few important points. Immigration law is federal law, and states have very little say in what ICE can do within the state borders. There's not a whole lot that you can do to stop ICE. However,
that's what's so scary about them.
However, there are limits on what the federal government is allowed to do or to compel the states to do. But here's an article from 2013 that's at least worth mentioning. There was at one time something called the Fugitive Slave Law, and it required the states to assist with the capture and return of fugitive slaves. And there was a Supreme Court case, Prigg v. Pennsylvania. And we're not going to go through this because it's a very long case. But the case decided that there are limits on how much the federal government can compel states to implement various federal laws. There are some things that the federal government has absolute power to regulate and the states have to comply, but then there are other things that the states don't have to comply with. And in this case, with the Fugitive Slave Act, they did not have to comply. I'll read this section here that they've highlighted. The fundamental principle applicable to all cases of this sort would seem to be that where the end is required, the means are given, and where the duty is enjoined, the ability to perform it is contemplated to exist on the part of the functionaries to whom it is entrusted. Remember, this is 1842 language. The clause is found in the national constitution and not in that of any state. It does not point out any state functionaries or any state action to carry its provisions into effect. The states cannot therefore be compelled to enforce them, and it might well be deemed an unconstitutional exercise of the power of interpretation to insist that the states are bound to provide means to carry into effect the duties of the national government, nowhere delegated or entrusted to them by the Constitution. Then there was an early 90s, I'm guessing 1990s, New York State sued the federal government, asserting provisions in the low-level radioactive waste policy amendments of 1985 were coercive and violated its sovereignty under the 10th Amendment. The court majority in New York v. United States agreed, holding that because the Act's take title provision offers the states a choice between two unconstitutionally coercive alternatives, either accepting ownership of waste or regulating according to Congress instructions, the provision lies outside Congress enumerated powers and is inconsistent with the 10th Amendment. So, with this whole thing, with whether a state judge has obstructed justice, let's look at what the actual charges are and then kind of put this all together into one sort of shitty watercolor picture. No trademark infringement intended. There's also a section here about perjury that I'm going to skip, that someone lied in the process of the investigation. So count 1 is obstruction of justice, conspiracy to obstruct justice under 1512K of the various obstruction of justice acts. Then we have aiding and abetting and obstruction of justice under 1512C2, and then 18 U.S.C. 2 is this section 1, the second one, and that's just the aiding and abetting provision. And then obstruction of justice under 1505, and then the perjury count. So let's take a look at these obstruction of justice charges. Let's start with 1512C2, because that's actually not the conspiracy one, and this will make a little more sense if we do it that way. So here's the obstruction of justice chapter, which is section 1501 through 1521. And we're looking at, what did I say, 1512C2. So 1512C2 is tampering with a witness, victim, or informant. So I'm not sure here. We just read all that. Was AS, the alien subject or whatever they were calling that person, was that a witness? Was that a victim, or was that an informant? I don't know. You decide for yourself. So this was C2, not A, which is whoever kills, not B, which is whoever intimidates, but C, whoever alters, destroys, mutilates, conceals a record, document, or object with the intent to impair the object's integrity or availability for use in an official proceeding, or 2 here is C2 is what we're talking about, or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so shall be fined under this title. That doesn't sound like that's instructing states on how to implement the thing, so I'm not sure that that's going to be able to coerce a state to act in a certain way, especially without saying how. Otherwise, that would grant the federal government unlimited, a virtually unlimited authority over the state, and the state would have to do all sorts of things if the state has to comply with that law in that way. However, it seemed like quite an overt act to try and get this AS person out of the courthouse in a way that would keep ICE at bay enough time for that person to get away. So it does seem like quite an overt act, right? At some point it's going to cross the line. If the judge had gone to... If the person was being held in the holding cell for ICE and the judge went and released them without a court hearing or anything, but the person was being held on the charges that the judge was hearing and the charges were being dropped, and the person was being released. So was it obstruction of justice to help them avoid the ICE officer that the courthouse either had? It wasn't really inside knowledge, but they had advanced knowledge that the ICE officer was going to be there. Let's continue with our analysis here, because we've got more than just 1512C2. We've also got 1512K. So let's go back to 1512 and go down to EFGHK. Whoever conspires to commit any offense under this section shall be subject to the same penalties as those prescribed for the offense, the commission of which was the object of the conspiracy. So that's just the felony murder rule for conspiracies under obstruction of justice. If you've conspired to obstruct justice, you're guilty of obstruction of justice, same way. Now, but this is the same thing we just talked about. So it has to be under this section, and the section they cited was C2, which was to impede any official proceeding. And I'm not 100% certain that we were in the middle of an official proceeding, especially given the Prigg v. Pennsylvania that we saw before. And then let's go one step further. What do we have here? Count 3 is 1505. Let's go bring up 1505. 1505 is obstruction of proceedings before departments, agencies, and committees. Whoever with intent to avoid, evade, prevent, obstruct, etc., any civil investigative demand duly and properly made under the Antitrust Civil Process Act. Okay, so I don't think we're under the Antitrust Civil Process Act. Or whoever corruptly, by threats or force, or by threatening letter or communication, influences, obstructs, or impedes endeavors, impedes, or do a proper administration of law. So it has to be corruptly done. It has to be by threats or force. It has to be by threatening letter or communication. And I don't see that here. Let's see. Or by threatening, influences, obstructs, or impedes, or endeavors to influence, obstruct, or impede. Shall be fined under this title. So I'm not exactly with them here. There's then this perjury thing, and if you lied to them, yeah, you can be hit with perjury. I'm not going to talk about that too much. So, what do you think about that? Does that sound like obstruction of justice to you? It doesn't actually sound like full-on obstruction of justice to me. Let me go one step further here, and we'll just literally type in obstruction of justice. Again, I'm not an expert on obstruction of justice. I'm a copyright lawyer. And I'm smart enough to know when I don't know something. So, obstruction of justice is a process crime consisting of obstructing prosecutors or other government officials, which I guess could include a police officer or ICE agent, sure. Common law jurisdictions tend to use the wider offense of perverting the course of justice. If you're looking at it at the state level, it's called perverting the court of justice if it's not called obstruction. Obstruction applies to overt coercion of court or government officials via the means of threats or actual physical harm, and also applying to deliberate sedition against a court official to undermine the appearance of legitimate authority. I don't know. Are we undermining the appearance of legitimate authority so much as he doesn't actually have authority at the state court level to coerce? It's the opposite. The police officer or ICE agent cannot coerce a state court official? Or is it more like he followed all the right procedures, he sent in his warrant, he had a warrant, and they helped... They prevented him from at least having the same notice that they were releasing the guy. They gave the AS person advance notice that the ICE agent was coming. They released the person from the holding cell with advance notice and delayed the ICE agent. So, where's the line here? Where does it become obstruction of justice? Let's keep going with Wiki. Generally, obstruction charges are laid when it is discovered that a person questioned in an investigation other than a suspect has lied to the investigating officers. However, in most common law jurisdictions, the right to remain silent can be used, etc. If a person willfully and knowingly tries to protect a suspect or to hide from investigation of their own activities, this may leave them liable to prosecution. Obstruction charges can also be laid if a person alters, destroys, or conceals physical evidence. Obstruction can include crimes committed by judges, prosecutors, attorneys, elected officials in general. It is misfeasance, malfeasance, or nonfeasance in the conduct of office. Most commonly, it is prosecuted as a crime for perjury by a non-government official, primarily because of prosecutorial discretion. Bill Clinton was impeached for obstruction of justice, although later acquitted in the Senate. For lying about his relationship with Monica Lewinsky. Richard Nixon was being investigated for obstruction of justice. Scooter Libby was convicted of obstruction of justice. Conrad Black was convicted. He removed 13 boxes containing financial records from his office after they had been sealed by a court order. Barry Bonds was convicted of obstruction of justice for testimony in front of a grand jury. His conviction was later overturned. This seems to me like we only charge obstruction for the really, really worst egregious cases of destroying evidence or lying to a court. I don't know where we have the intersection of federal agents and state courts. I don't know that there is a way for the federal government to compel the state to assist the ICE officer, and that's what I think is going to happen here. I think that this indictment is meant as a violation of the judge's rights, is meant as a message to try and chill any behavior or any further, not, whether you want to call it obstruction or not, any further assistance that judges might have to give to immigration defendants. Or should I say, parties in a court case that might be involved in an immigration case elsewhere. But I off the top of my head, my lawyer senses are saying that this is well established that the federal immigration law cannot compel state courts to assist ICE officers. I'm like 99.9% sure on that. And if someone called me with that question, I would feel comfortable saying that they need to go and find more information about that. But that's my gut response, is that there is separation there. At some point, there's a line. If the judge said, wait here, I'll go get him, and then helped the guy out the back door in the broader sense, yeah, that might be the thing that crosses the line where it's no longer just that the judge, let the guy out the back door, but that the judge told the ICE officer, you're not going to be allowed in my courtroom. You can't witness these proceedings. You're going to have to wait here. And then that part might be the active part for obstruction of justice. If anything, that's where I would expect the government to focus, on the active parts. But it might not matter, because there might be such a legal separation between the two entities, federal and state, that you might not be able to compel the judge to do anything at all. Sort of immunity, a sort of sovereign immunity almost.
Now, according to the transcript, so the judge at first, told the ICE agent to exit and said, "Don't worry, he'll leave by the front door," and then was informed that there might be that it might be a case of mistaken identity, and so the judge was like, "I'm not sure that this warrant is for the right person." So is the mentality of the judge being like, I don't know if the warrant that these guys have is legit? Would that factor into obstruction of justice?
I think so. And my analysis would go something like this. So the law that was written, so really briefly going back to that Prigg v. Pennsylvania case, basically said that the law needs to delegate authority. And so if the federal government has authority over the states to say you have to behave this way in immigration situations, then it has to say so with clarity, with particularity, to say, you must assist agents in transferring state or incarcerated arrestees or whatever to ICE whenever requested. It doesn't say that. It says if you interrupt a proceeding, you're guilty of obstruction. Well, what's a proceeding, and where's that line? It seems unconstitutionally vague to me. So where's that line then? If this is true, if it's true that the state can be compelled and the judge can be compelled, not just to allow the ICE officer access and all that, but to also assist the officer, what's the line? Is it obstruction if we don't walk you down to the holding cell and show you where everything is? Is it obstruction if we don't get you coffee because you're going to be waiting for a while? Is it obstruction if you can't use the bathroom because there's no bathroom in the courthouse facility, but you're going to be there for 3 hours or something? Where is the... I'm using ridiculous examples there, but then let's think more particularly, what facilities have to be provided to house the people that are being held while waiting for ICE? What if the state doesn't have the facilities and they aren't being held on state charges, so they have to be released? So who's guilty of obstruction there? Is that the judge? Is that the prison? Is that do you arrest the governor of the state because they didn't provide enough prison facilities or holding facilities? So there's gotta be a line that prevents the federal government from just walking all over the state's rights in governing the state part of things. So the state doesn't have to govern immigration. The state doesn't care about immigration. The state's not assigning its state police officers or local police officers to find immigration people, and the state can't be compelled to do so. So how can they say that a judge can be compelled to do so? And up to a certain point, the judge can't be compelled to do so. And the question here, I think, is did the judge take active enough steps, overt enough steps, that crosses the line into obstruction of justice? And a grand jury thinks so. This is a grand jury indictment. So that's sometimes what's the phrase? A federal grand jury would indict a ham sandwich. So we'll see what happens there. I don't expect that this judge will actually be guilty of obstruction of justice. Maybe the perjury charges for Wesley McGregor, the staff that may have lied, that might happen. I think it's just a message. I think that the case is being used as a way to send a message to any official that might get in the way of ICE. I think it is being used as a club or a billy club or intimidation tactic, which is sad because we really should be able to have a legit question or legit debate about the immigration problem and come to a conclusion and solution that we can all work together on. And instead, Americans don't seem to be willing to work together on anything anymore. They seem to be about as divided as those computer graphics, those charts that were showing that Congress is literally has like no connections to each other. It's like two disconnected halves of a brain, and that's a medical condition. If your brain hemispheres are not speaking to one another correctly, you have one of various medical conditions.
Yeah, I saw Blackleaf jump in. Did you have something to say about the issue?
Yeah, sorry, I'm a little late to the party here, but Leonard, your analysis is correct as usual, and I think you're right. It's going to require more than the judge not complying with some sort of request or even a warrant. It's going to require some sort of active step, active interference, active lie, and the statutes you read don't seem to be correct either. So far, I'm thinking the judge has the better case.
Yeah, the one primary charge seemed to be about witnesses, and this isn't a witness. This was the actual criminal defendant. But I'm not sure. Maybe there's a broad understanding or broad interpretation of witness under that section. It's going to be more complicated to the audience. What I'm saying is it's going to be more complicated than just the plain text of the statute. Certainly we start with the plain text of the statute, but there will also be case law interpreting how deep you can go with the plain text of the statute. Does it really mean that anybody who obstructs... So So if let's say that I'm the defense attorney, let's just take this to its ultimate conclusion. If I'm the defense attorney and I tell my guy, hey, I saw the ICE agent coming in the front door, he's probably coming for you, you should head out the back. Am I guilty of obstruction of justice? I'm the guy's attorney. The defense attorney should be able to tell the guy just about anything that he should do, except really lie under oath is about the only thing that I'm not allowed to tell people to do. Or, obviously I can't tell people to hurt people or anything like that. But, as far as your court proceeding, is it obstruction if I tell the guy, you can defend yourself by not being where the ICE agent is looking for you? No. Well, why is it obstruction when the judge does it? Well, how about when the judge says to the ICE officer, wait here, I'm going to go let your guy out the back?
Yeah, that's where it's going to get a little bit interesting.
That's where it's much
what exactly
closer.
did the judge say?
Yeah, much closer to obstruction there. If the judge really did tell the ICE officer, yeah, your guy's going to be released this afternoon, wait here in the lobby, and then they had this private conversation, and then took the guy to the holding cell, and then released him, and then went to the ICE officer and was like, oh, he's been released, have a nice day. I can see why the federal government is super upset about that. That does seem like some kind of active obstruction, doesn't it? But does it reach a level of legally like charges that can be brought? I don't know.
Yeah, I think the grand jury reaching its conclusion, the threshold is so low, as you know, for the grand jury. It's like these questions are legally complicated questions. The Court of Appeals probably going to have to address at some point. So we can't expect the grand jury to figure this one out.
So the FBI has a tremendously high conviction rate when they investigate someone and they eventually bring charges. And I say eventually because it's usually some time. They have an incredibly high conviction rate. It's like 85% or better. This is not that. This is something that's being brought by the United States Attorney through a grand jury indictment. And like we said, the grand jury would indict a ham sandwich because that's what the federal prosecutor wants them to do.
And this will have huge impacts on the judge, whether or not she's eventually convicted, because I doubt she's allowed to continue to be a judge while she has a criminal indictment. And
you know what? I bet she is.
Oh, really?
Because
it's not a conviction, though.
Yeah, no, it's a state judge. It's going to be real interesting with the federal judge. I bet you the state judge is probably going to be on the bench. This is going to be fun for everyone. It's another in the endless squabble between the federal and state governments as to who has power. As you're pointing out, this goes back 1800s, Prince v. U.S., the gambling case from New Jersey from Scottus last year. Yeah, it's just another battle.
So this is a Washington Supreme Court case. This is a very weird situation. We'll get back to the update. But a man refused to open his door to let police enter his home without a warrant, and he was convicted of obstruction of justice. And the state Supreme Court overturned... This is really weird. The state Supreme Court ruled that it is not obstruction of justice to refuse to open your door for police, but the state Supreme Court did not have the votes to overturn the conviction. So the man remains convicted, but the law is overturned, and now the man's in limbo and has to figure out what to do next legally. Criminalizing the refusal to open one's door for a warrantless entry would be enormously chilling and inconsistent with our deeply held constitutional values. Yet the conviction is upheld. Washington appears to be the only jurisdiction in which citizens may be prosecuted merely for failing to yield when law enforcement demands warrantless entry. So that's a weird bit of limbo there. It appears to be not obstruction of justice in Washington state, but that one person's conviction is being upheld by sort of legal procedure chance there of just the justices' votes. I'm assuming that sort of thing can be appealed even further to a 10th or 11th Circuit Court of Appeals or something that's up there. But good luck to that defendant. So this is important. It can't be obstruction for you to simply refuse to answer questions or to refuse to let an illegal search of your home go on. So it's a broadly written law that has to have limits placed on it by courts. And so this is not just anybody who refuses to help a police officer is guilty of obstruction. You have to be careful, though, because there are various laws where if you refuse to assist a police officer in a time of emergency or crisis or exigency or something, you can be guilty of a crime very similar to obstruction of justice. So that's what I don't like about this case, is the messaging of it. We're going to use this to send a message about states helping with immigration. That's not how that works. And that's a scary thing to start allowing the federal government to encroach upon the states. A weird result, too, because the current administration that's enforcing immigration policies of its own making doesn't like the federal government encroaching upon states' rights when it campaigns. Just saying.
Yeah. As the most conservative person in this room, I'm quite confident saying that merely saying the police cannot come in has to be protected. I mean, the Constitution, it's a Fourth Amendment right. So this is bizarro world to me. I don't understand this.
So that is our show, everyone. Thank you for joining me for this another episode of Lawful Masses. With you, my lawful masses. So it's been a great Sunday. We talked about some great stories that are going to drop this week. Of course, I clicked on stories. The Prenda law victims, public service announcement, the ICE obstructing judge, the chalking tires being unconstitutional, games as a service is not fraud, and the fair use oopsie. I hope you've enjoyed our show today. This is a community-supported channel. Thank you very much to our Patreon supporters, our sponsors, our Twitch subscribers, and shortly here we'll have the YouTube join button turned on. Thank you very much to our April 2019 supporters at the $50 plus level: John Steele, Gavin Barnard, Eevi, Andy, Kyle Mudrak, Verement, Tayne, Michael Pearce, Terry Crisp, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, Aspernari, Snorre Wisotzky, Sean McNamara, Aetaric. Thank you very much for your support. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me, as well as will appear in the description of the video below. I am Leonard French, your favorite copyright attorney. I'll leave some room here for our editors, including me, to have some dog video in the outro. So I love you very much. Have a great week. Bye. All right, I have a very fun case I think it's going to be fun for the next one.